Hi, I'm Kristen Armstrong. I'm an estate planning and elder law attorney in Hutchinson, Kansas. I'm going to talk today about revocable trusts. What is a revocable trust and how can somebody use a revocable trust? Most people, when you ask them, they will say that they want to avoid probate. They may or may not know what that means. They may have heard of the word revocable trust. They may know people who have revocable trusts. They may or may not understand exactly what they mean. So let me explain to you a little bit about what a revocable trust is and how it can be used to help you avoid probate. I've created a fictitious scenario here. And my couple, let's pretend that John and Carol have come into my office for some estate planning advice. John and Carol have been married for 35 years. They have 3 children whom they adore. They also have several grandchildren whom they also adore. They wish that they could see them more frequently, but they do get to talk on the phone regularly and have been able to do video chats. They have heard that they want to avoid probate, but they don't necessarily know what that means, so they've called on me to help. Here are some of the assets that John and Carol have. They own their home, they have retirement accounts, vehicles, savings accounts, checking accounts, CDs, life insurance, a money market account, and an investment account with their local retirement account agent, financial planner. Here's how the assets are currently held. John has his own checking account. Let's pretend that Carol has her own as well. So we're going to add her down here as well. Carol. There we go. Carol needs her own checking account as well. So John has a checking account and he has a beneficiary on there. It's Carol, meaning when John passes away, Carol gets the account. They also have a savings account. It's titled in the name of John and Carol, and it is joint with rights of survivorship, meaning if John passes away, Carol becomes the account owner. If Carol passes away first, John becomes the account owner. John also has an IRA from when he worked in the past. Carol is the beneficiary of that account. Carol has her own IRA. John is the beneficiary of that account. Now, I will stop here and say it's a common misconception. If you ask somebody, sometimes they will say, we're both joint owners on all of our accounts. But what they fail to recognize is that IRA stands for Individual Retirement Account, meaning that account can only be in the name of one person. Thus, that is why John is the only owner of the IRA and Carol is only the owner of her respective IRA. It can never be John and Carol. It can only be one. John also has a 401k, which he has not moved from his employer. John has life insurance, and he also has a beneficiary on the life insurance policy. The house is owned with joint tenancy with rights of survivorship, meaning John and Carol both own the house. Whenever one of them passes away, the ownership will vest solely in the other, the survivor. Notice that there is no beneficiary on the house. Thus, the house would go through probate in order for anybody to be deemed the beneficiary or the heir of that house. The vehicles are also owned joint tenants with rights of survivorship. There is no beneficiary on the vehicle titles either. They have an investment account. The investment account, joint with rights of survivorship. No beneficiary on this account. Money market, titled joint tenancy with rights of survivorship. No beneficiary. All of these assets, the house, the vehicle, the investment account, and the money market account, as well as the savings account up here, are going to have to go through probate unless they take some steps to avoid probate. And then don't forget, we added Carol's checking account here as well. One of the ways that they can avoid probate is using a revocable trust. Here, they don't have to necessarily use a revocable trust. They might be able to accomplish their wishes with beneficiary designations, but we're going to dig into a little bit more of the nitty-gritty about what Carol and John want to happen. Here are their goals. They want everything to go to the other spouse if the other spouse is still alive. Thus, if Carol's still alive, John wants his stuff to go to Carol. If Carol is still alive, she wants everything of hers to go to John. When they are both gone, they want everything to go to their children. But if their children pass away before they do, then they want it to go to their grandchildren. So let's say that their daughter, Susie, dies before John dies. Then Susie's kids, they want Susie's kids to be the beneficiary. Okay. The oldest grandchild is age 22, and the youngest is the oldest grandchild 22, and the oldest is only 10. I'm going to change this a minute here. They don't want anything to go to their daughter's husband because they don't really like him. And they do really like their son's wife, but they don't really want to leave her anything either. One of the grandchildren is autistic, and they're also worried about that. So for John and Carol, because we have younger grandchildren, even though the oldest is age 22, let's say that John and Carol have $500,000 in assets, including their real estate, including their retirement accounts. And if they were to sell every single thing that they have, their estate is worth $500,000. Would they want one of their grandchildren at age 22 to get a share of $500,000? Maybe, maybe not. Maybe we want the 22-year-old to wait until they're 30 or 35, or maybe we give them some at a certain age and some at a later age. We can write those kinds of provisions in a revocable trust. Now, the youngest is only 10 years old. Would we want a 10-year-old child to inherit any property at all? No. That would make the child have to go through a court concept, which is through the probate court, called a conservatorship, and the court would oversee the money until that child turns 18. Here again, you have the same problem. Do you want the 18-year-old child to get their hands on a somewhat large sum of money? Probably not. Again, we can write those kinds of provisions into a revocable trust. So how does the trust work? Well, John and Carol are alive. They go to their estate planning attorney, and we create a trust. And this is the trust. Let's pretend this coffee mug is my trust. This is the trust. The trust is controlled by a trustee. The trustee is holding the trust and taking care of the trust. While John and Carol are alive, it's our goal to help them fund the trust. So the trust sets forth the rules. It says, when my kids pass away, when me and my wife pass away, we want everything to go to our children. If one of our children dies before us, we want it to go to their children, but we don't want their children to get it outright because we want their children to only get it at certain ages. And we're also worried about our grandchild who is autistic, and we don't want him to lose any of the benefits that he might be on. So we want to take care of special needs provisions inside of this trust as well. So we have this trust. John and Carol are going to control the trust while they're alive. It's a revocable trust, and they are the trustees of the trust. They are the holder of the trust. When John and Carol pass away, they're going to pass this trust off to another individual. Probably one of their kids. It could also be a professional trustee, such as an attorney or an accountant or a bank with a trust company. It could also be another family member or a close friend. But the trustee is going to look inside the trust, read the rules of the trust, and see what we're going to do with it. Now, if John and Carol set up this trust and they never put anything in it, and when they die, it goes over to their trustee, and the trustee looks inside and there's nothing in it, Well, by golly, we haven't done anything to avoid probate because everything is still out here and it was never inside the trust. So John and Carol messed up. They created this trust, but they never put anything in it. So the trustee doesn't have anything to pour out. Okay, so we'll back up. John and Carol, when they go in and they see their estate planning and their elder law attorney, the elder law attorney says, John and Carol, we need to put your house in your trust. So we put the house in the trust. They say, John and Carol, you need to make sure that your vehicles are in your trust, or at least go in your trust upon your death. So we put those in the trust. John and Carol, we need to make sure your bank accounts are in the trust. So we retitle the bank accounts. I'm adding things into this trust, okay? Money market accounts, CDs, we want those to go inside the trust. Retirement accounts, remember, those are IRAs, individual retirement accounts. They cannot go in the trust, but they can go on the trust, into the trust upon John and Carol's death. So we want to make sure we have updated all beneficiary designations so that everything is in the trust. So not only do we have a trust, but we have what we call a funded trust. Everything that John and Carol own are in this trust. So when they die, the trustee can be changed from John and Carol, and it will be passed on to their successor trustee. Their successor trustee is going to look inside the trust and see that each of the kids get their fair share, and we take things out and we can administer this estate. Nothing goes through probate because it has passed via the revocable trust. Okay. A revocable trust does nothing to protect against long-term care costs or any other kind of lawsuit. It is not an asset protection trust whatsoever. That's a different kind of trust called an irrevocable trust. We're not going to talk about that today. Today, we're only talking about the revocable trust and how it is used as a probate avoidance tool. Please let me know if you have any additional questions or if you have any questions about the revocable trust, about the trustee, about the funding of your trust, or how you can create a trust.